May I please, Lordship? Lordship, I beg to mention for listing of writ petitions, Lordship, at the last item, Lordship. Lordship, this matter I filed on Monday, Lordship. Lordship, my case was that, Lordship, the petitioner lands was acquired by the respondent authorities, Lordship. However, Lordship, compensation was paid, Lordship, but the solertium and interest have not paid till yet, Lordship, as per the Land Acquisition Act, Lordship. That is my case, Lordship.
Next Monday.
Lordship, today I'll be going to Guwahati, Lordship. That's why, Lordship. I waited since Monday, Lordship. If
Then the Tuesday next. This is not an urgent matter for listing today.
Lordship, in that case, my Lordship, I may be allowed to appear through VC, Lordship, on Monday.
Okay, all right.
Humbly obliged, Lordship.
May I seek your lordship indulgence of mentioning part 2, item number 12. My lord, kindly give this matter specific date.
Item number
Part 2, item number 12.
12. Hearing matter. On the basis of the submission made by the learned counsel for the appellant, the hearing is adjourned today. On 19 May for hearing. Okay.
Daily list for motion, item 1.
May it please your lordship.
Is it your land? The
Yes,
land-
it is my property, lordship.
Your property.
Yes.
Today notice will go.
Your Lordship, if I may, in the last court date, I was instructed to obtain instruction regarding the matters. And as per my instruction, Your Lordship, it is true that the retaining wall were erected, but however, not in the land of the private land. It was erected on the hillside, and now there is a draft to erect the retaining wall again.
The excavation was not done in the land of the petitioner.
No, not yet. So the case is infructuous, and moreover, Your Lordship, there is a settlement between the parties. They contacted the appellant, and the appellant instructed the authority that if his land is not interceded, he has no problem. So now there is no case at all, because the
Yes.
Lordship, if I may mention, lordship, the excavation has already started, lordship, and it is also within the petitioner's land. And however, lordship, we can see from the pictures as in from the annexure, lordship, when on 11th of April, lordship, there was some measurement done by the Land Revenue Department, and it was clearly shown that it was within the petitioner's land, lordship, within around 18 feet of it, lordship. Now, lordship, our only concern is that although the excavation may be for the public purpose, lordship, but the excavation which was done on the petitioner's land without any information to him, without any notice to him, lordship, which is our main concern, lordship.
Whether you file a counter affidavit.
yes, Your Lordship.
Heard, Mr.
Samuel L. Patsua.
Appearing for the petitioner. Heard, MS so-and-so. The learned government advocate.
Your Lordship, in the last court date, notice was not issued yet.
Huh?
Let notice be issued.
No, notice will be issued. You are government advocate.
Yes, Your Lordship.
Heard, MS so-and-so, the learned CA. Issue notice. No formal notice is required to be sent to the respondents as because MS so-and-so has accepted notice. Extra copy of the petition shall be provided to her. Least after 2 weeks for admission hearing.
Much obliged.
For admission, item 2.
May it please your lordship? Your lordship, in this particular case, the Advocate General is going to appear in the matter.
Yes.
And your lordship, this case particularly, it requires a full-fledged hearing, and the Advocate General will be appearing as.
Advocate General.
Yes, your lordship. So if
My lord,
Malhotra is also there. You have put a private respondents.
It appears, Your Lordship, that the AG is appearing. He has some personal difficulty today. And he has requested that the matter may come up on the 14th of this month.
14th.
Yes.
my lord, if may allow. My lord, in the last two hearing also, the adjournment has been sought on the same ground. And my lord, I have well cooperated in those adjournment also. Now, my lord, I would like to rely upon a full bench judgment of Supreme Court, Pratish versus State of Maharashtra, which clearly states that under application 340 CRPC, the would-be accused have no right to be heard. So, my lord, if they have no right to be heard, then adjournment cannot be granted. My lord, this is
Your
the.
Lordship, anyway, my learned friend is being very technical. This is a writ petition, civil writ petition, in which they have filed a miscellaneous application to initiate a criminal inquiry. But since the learned AG is appearing, and since he has his personal difficulty due to the elections in West Bengal yesterday, so I mean,
My lord, this is a serious matter. A forged document has been presented before your lordship and has been presented as a true document and has been relying upon heavily to get a favorable judgment. My lord, may come to para number 18 of this judgment. My lord, it says, we are unable to agree with the said view of the learned single judge, as the same was taken under the impression that the decision to order inquiry into an offense itself would prima facie amount to holding him, if not guilty, very near to finding of his guilt. We have pointed out earlier that the purpose of conducting preliminary inquiry is not for the purpose at all. The would-be accused is not necessary for the court to decide the question of expediency in the interest of justice that an inquiry should be held. We have come across a decision of some other high courts which held the view that person against whom proceedings were instituted have no such right to participate in a preliminary inquiry. We therefore agree with the impugned judgment that the appellant cannot complain that he was not heard during preliminary inquiry conducted by the reference court under section 340 of the code. My lord, this IA is also under the same provision.
Okay, all right. You are Mr. Jain.
Yes, my lords.
What? TC Jain.
Yes, Your Lordship.
T Jain.
Karthik Jain.
Kartik Jain. Heard Mr. Kartik Jain appearing for the petitioner. Heard MS
Miss Lalun Lui, Your Lordship.
appearing for the state respondents. Heard Mr. A.R. Malhotra appearing for the private respondents. MS so-and-so submits that in this case, the learned advocate general will appear and therefore she prays for some time. On the other hand, Mr. Jain has submitted that in view of the judgment of the Honorable Supreme Court that was delivered in Pritish versus State of Maharashtra and others, reported in 2002, 1 SCC 253, the accused,
Would be accused. Would be accused.
the would-be accused do not have any right to be heard. But I have considered the submissions made by the learned counsels on both sides. The prayer of the state respondents is allowed as prayed for. Release this matter on 14th of May.
Much obliged, Your Lordship.
For orders, item 3.
May I please, Your Lordship?
Yes.
My Lord, in this case, the appellants failed to appear on the last occasion, and it has been fixed for today. In this case, my Lord, the appellant defendant have been directed to, the decretal amount is rupees 18 lakhs. And after filing the appeal by the appellant defendant, my Lord, they have admitted their liability.
Okay, one last chance I will give. I will give one last chance.
Yes, my Lord. My Lord, if I may, since the appellant is engaging counsel from our station, and they have continuously failed to appear, my Lord, I may be allowed to take fresh step upon the appellant
You want to take fresh steps?
Yes, my lord, because earlier the appellant in person had appeared
Oh, it's,
and had admitted his liability,
okay,
and we are waiting for the payment of the remaining amount.
okay. None appears for the appellant on call. The appellant has been absent on call on more than one occasion. Mr. So-and-so appearing for the respondent.
Number one.
Number one submits that he wants to take steps for service of a notice upon the appellant.
Yes, my lord.
The prayer of the learned counsel is allowed. The notice shall be issued to the appellant by speed post.
As well as Dusty.
Huh?
In addition, Dusty. In addition to that, my lord, I may be allowed to take steps
Fresh
by way of Dusty. Dusty.
Dusty.
Yes, my lord.
The appellant is also at liberty to serve the notice by Dusty. Notice upon the appellant by Dusty. Least after 4 weeks.
Deeply obliged.
Item numbers 4 and 5.
Your Lordship, my
Yes.
senior is having some personal difficulties. Can the matter be listed after 1 week for admission hearing?
You were in both the cases.
Yes, both the case, 4 and 5.
The learned counsel MS so-and-so appearing for the petitioner submits that the learned conducting counsel, what is his name?
Let Fakoma.
Has some difficulty today, and on that ground an adjournment has been prayed for. Heard Mr. So-and-so appearing for the respondents. The prayer for adjournment is allowed. When do you want it?
After 1 week.
After 2 weeks.
After 1 week.
After 2 weeks.
Okay.
Least after 2 weeks, along with item number 5.
Deeply obliged.
Yes.
May I seek your lordship indulgence in mentioning for item number 11, which is WPC 25. Due to inconvenience of the petitioner's leading counsel and also with the consent of the opposite party.
Which
may
one?
the, item number 11, part 2.
Part 2.
Yes, my lord. May the matter be taken up after 2 weeks, my lord.
After 2 weeks.
Yes, my lord.
Item number 11.
Yes, my lord.
Both sides are duly, heard the learned counsel for the appellant. You were for the appellant?
Yes. Petitioner's counsel.
Item number
11, part 2.
part 2.
WPC 25.
11. 11 is a appeal.
No, my lord. Yes.
Which is the hearing this? This one. This is the hearing list. Oh, it's item number 11. Oh, you are for the petitioner.
Yes, my lord.
Mr. So-and-so appearing for the petitioner. Prays for an adjournment. And on his request, the matter be listed for hearing on when?
Listed after 2 weeks, my lord.
List after 2 weeks for hearing.
Yes, lord.
Okay.
Pledge.